Hi, my name is William and I'm a hospital attorney.
And I'm Dr. James.
Today Dr. James and I are going to teach you about the physician's self-referral law, better known as Stark. All rights to the content of this movie are reserved to Iseman, Cunningham, Riester and Hyde, LLP, copyright 2011.
I know everyone in the audience is as excited as I am to learn all about Stark. So, William, why don't you start off by telling us what Stark is?
Under Stark, a physician who has a direct or indirect financial relationship with an entity may not make a referral to that entity for the furnishing of DHS, for which payment otherwise may be made under Medicare, unless an exception applies.
William, you lost me at financial relationship.
Okay, let me try to simplify. For purposes of our discussion we are going to focus on doctors and hospitals. Stark applies if there is a financial relationship between a doctor and a hospital. No financial relationship, no need to worry about Stark.
William, what constitutes a financial relationship?
Any time a doctor receives something of value from a hospital, a financial relationship is created. For example, let's say the hospital has an annual medical staff appreciation event at Jones Beach. At the event, the hospital gives each doctor a tote bag full of free gifts valued at $200. By attending the event and accepting the free gifts, you've created a financial relationship between yourself and the hospital.
So by attending the staff appreciation event and accepting the free gifts, I become subject to Stark?
Yes.
Do I violate Stark by attending the event and accepting the free gifts?
No, because there is a non-monetary compensation exception that covers one medical staff appreciation event per year, and freebies valued at up to $359 per year.
What if the free gifts in the tote bag were valued at $400 instead of $200?
Accepting freebies valued at more than $359 will create a non-compliant financial relationship between you and the hospital. The hospital cannot bill Medicare for the DHS referrals you make to it, when a non-compliant financial relationship exists.
William, what does DHS mean?
DHS stands for Designated Health Services. The Stark statute has a list of all the services that are considered DHS. Inpatient and outpatient hospital services are included on this list.
If I don't refer DHS, will I create a Stark violation by accepting the tote bag with free gifts valued at $400?
No, if you do not refer DHS to the hospital, Stark will not apply to any of your financial arrangements with the hospital. No referrals of DHS, no need to worry about Stark.
William, does accepting wages as an employee create a financial relationship?
Yes, but don't worry, those payments are covered by a Stark exception, provided your salary and benefits are within fair market value for the services you provide to the hospital.
William, if I am an independent contractor, and I accept money from the hospital for providing services, do I violate Stark?
Maybe. It depends.
You weren't kidding when you said you were a lawyer.
For the sake of our esteemed audience, I'm going to pretend I did not hear that. The Stark exceptions for professional, administrative or teaching arrangements have very strict and complex requirements. As long as your arrangement meets an exception, the cash payments made to you for your services will not lead to a Stark violation. The lawyers can figure out the nitty-gritty details, but the doctors in the room need to remember two things. 1. Make sure any contract for services is in writing and fully executed before you begin providing services, and 2. Make sure you are getting paid fair market value for your services.
Okay, get it in writing before I start providing services, and make sure I am getting paid fair market value. Got it. What if the hospital only pays me $100 for my services? Do I need a written contract?
Yes.
Really? That seems a little absurd. Are you telling me there is no Stark exception for nominal cash payments made to a physician for services he rendered to the hospital, without a written contract?
Yes, that is precisely what I am saying. There is no Stark exception for nominal cash payments. If you receive cash payments without a written contract, and you make DHS referrals to the hospital cannot bill for those services.
Even if the hospital rendered the services and the patient received the care needed, the hospital cannot bill Medicare for the services?
Correct. The hospital cannot bill Medicare for any DHS referrals you make while a non-compliant financial arrangement exists. It does not matter if the payments that create the financial arrangement amount to $10,000 or $100.
So, let me get this straight. If the hospital made weekly payments of $100 to me during the month of January, to provide lectures to medical school students, and the arrangement was not in writing, the hospital could not bill Medicare for the $50,000 in DHS referrals I made to it during that month.
Correct. If the hospital billed for those designated health services, it would be a stark violation. Do you get it?
I got it. Do you think the members of our audience get it?
If they do not, Rachel Ryan from Iseman, Cunningham, Riester and Hyde, LLP can answer their questions. Don't forget, if you are a doctor who wants to enter into a financial arrangement with the hospital, make sure it's in writing and it is for fair market value. Thanks for listening.